Mr. Sauter, I think, told you, only the attorneys arguing the case should have their video and their microphone on. If everyone else would please make sure that their audio and video are off. The first case on our docket today is Vogel versus Albee. That will be followed by Ayer versus Morenz Harbinger, followed by State versus Donald Williams. And we have a fourth case in our docket today that has been submitted, State versus Tracy Williams. So we will start with Vogel versus Albee. Counsel, if you can both indicate your readiness to proceed and introduce yourself to the court.
Eric Holzapfel for the plaintiff appellants. We are ready to proceed.
And Mr. Holzapfel, your video is not on. It's okay if it's not on, but if you want us to be able to see you.
Is it on now, Your Honor? I think
all I'm seeing is a black screen.
Oh, well.
You should have a video icon that says stop video, start video.
Here's a video. It says it should be on.
Is your camera, there's an on-off button on the camera as well, perhaps on your laptop or device.
Live. Well, video setting, visual video. General.
So let me, while you're trying to figure that out, let me move on then. And counsel for appellee.
Good morning, Honors. Bob McMahon on behalf of Third Street Associates LLC and Frank Albee. We're prepared to proceed.
All right, thank you. Mr. Holzapfel, rather than hold things up, we can hear you fine.
Okay.
So I'm going to ask if you will just do your argument the way it is now. And would you like to reserve any of your 15 minutes for rebuttal?
Yes, I'd like to reserve 5 minutes.
All right. And whenever you're ready to proceed, you may proceed.
Thank you, Your Honor. This is a contract case. I've been litigating contract cases for about 50 years almost. I've never had one like this one where both parties agreed on the terms of the contract and agreed there was an offer and an acceptance of those terms. And we have that here, and the record amply supports what I just said. The contract terms are pretty simple. There are 4 terms, $400,000 cash, the price, $400,000 cash, a second term, close in 30 days, and approval by Vogel's attorney. It's in exhibits 2, 3, and 7. Those 4 terms were specifically acknowledged by Albee's agent, Vicki Blackman.
Mr. Holzapfel, can I interrupt and ask you a question? There's an email from Ms. Blackman to your client on December 5th, where she talks about the premium, the $20,000 buyer's premium that would bring the total price to $420,000. So my question for you is, does this contract, as you envision it, is it for $400,000 or $420,000?
$400,000. If you look at the offer in exhibits 2, 3, and 7, it was for $400,000. They later acknowledged, the defendants referred to the offer as the $400,000 offer in a number of emails. So it's $400,000.
Well, but I see that, but she also explains that the $400,000 offer is really a $420,000 offer. So one way of reading those emails is by referring to the $400,000 offer. It's actually $420,000.
Well, that was not in, and I think if you look at the record in its entirety, the offer is contained in exhibits 2, 3, and 7. That was Vogel's offer. He didn't offer 420. He never offered 420. He offered 400. And she acknowledged in her.
Well, but he did say, okay, let me know, when she said that. He didn't say, wait a second, my offer is only 400,000, not 420,000. And I think that the bigger issue that this implicates is when we're talking about email back and forth, this looks like a bunch of emails that I've seen over the course of my career, which leave a lot to the imagination. And there isn't a specific email that says, I hereby offer you $400,000 for this specific property on these terms.
Well, we have the testimony. If you look at Vicki Blackman's testimony, I asked her what the 4 terms of the offer were. And I said it was $400,000 cash, close in 30 days, approval of attorney. She admitted those were the 4 terms of the offer by sworn testimony. She also testified that she conveyed that 4-term offer to defendant Albee. And she, in addition to saying that she acknowledged those were the 4 terms, she did this under testimony. She acknowledged that there were no other terms, no extraneous documents that needed to be signed. It's in her.
Well, can I ask you a question about that? Because there's an email from your client where he does seem to suggest that he needs to sign a document. Wasn't he anticipating signing a document?
Well, at the end, after Albee had accepted our offer, and after Blackman had communicated that acceptance to us, they got another offer, and a better offer. And so suddenly they decided that the offer they accepted, they didn't want to deal with anymore. And the agent tried to wiggle out of the contract by confusing my client, who's not a sophisticated real estate developer or owner, and tried to say, well, you didn't sign the document. He was not aware of the Electronic Signatures Act impact on the fact that an email with a name can be a signature. And so she had a dilemma with her seller because she had communicated an acceptance of the 4-part offer to my client. There's no dispute.
Mr. Rosopel, let me ask you a question. Let's assume that there was an offer and an acceptance. There is in the emails stream a bold boxed statement that says, any written or verbal acceptance of an offer amount as relayed by seller's agent, so let's say we have that, is contingent upon receipt by seller's agents of the required contract. Did your client ever sign a contract? And what I'm asking is, assume that's a contingency. Was that contingency ever fulfilled?
I don't believe it was a contingency, because what you're pointing to, Your Honor, is a boilerplate language at the bottom of every email that she ever sent, and there's other boilerplate language down there. That was never.
This one's in big bold. It's got a big bold box around it, like an FDA box warning.
It was not part of my client's offer. I mean, contracts, as I understand it, is offer. And if the acceptance, you're entitled to make the offer you want to make. You make an offer.
But I guess how is it not part of your client's offer if your client said, my attorney needs to review it? And I assume by it, he means the contract, right?
No, not at all.
What does he need? What does his attorney need to review then?
He wanted me, his attorney, to approve the deal. He always did that. He made it a term of the contract, which he's entitled to do. It was the 4th term of the contract for me to approve it. But what is it? That's my question. He says, I send it to my lawyer. What is it? The deal. The deal.
What does that mean?
Well, he's not a sophisticated real estate.
I mean, you're not persuading me on he's not sophisticated. He says it. To me, that means a contract. If it's not a contract, what does it mean?
It means the contract that he has just entered into. He wanted me to approve the terms of the contract. 400,000 cash and close in 30 days. He wanted me to approve that, and they made that part of his offer, and they accepted that offer.
Mr. Hosoffel, if that was a contingency that flowed only to your client's benefit, let's assume that.
Yeah.
Then did that contingency happen? Did you approve it, and therefore that contingency is gone?
I never had a chance. Within hours after they accepted my client's offer on December 7th, they reneged. That same afternoon, after they got their better offer in, they reneged. I never had a chance to approve it. I would have approved it, but I didn't have a chance. So, and I understand your point about that stuff at the bottom, but my client did not incorporate that into his offer. Now, what they should have done, if they wanted to change the 4 terms that he offered, they could have said, well, Albee could have said, okay, well, let's tell Vogel we will accept his offer if he signs a formal contract and if he pays more money, A, B, and C. They never did that. That would have been a counter offer. What they did
I'm sorry, if your client had signed the written contract and sent it back, maybe that would have satisfied that black box contingency.
Well, it wasn't part of the contract, Your Honor. That's the thing that I'm apparently not getting.
Well, ultimately, it would have had to have been, because you couldn't have. Is your position that there was never any need for anything further and that the title would transfer?
Yes, that is my position. Under the Electronic Signature Act, emails are writings. It satisfies the statute of frauds. We made a 4-part offer. They acknowledged the 4 parts. They acknowledged they communicated the 4 parts to the seller, and the seller said, tell Vogel we are accepting his offer. That's a contract, and I tell you, in 50 years experience, acceptance meets offer. It's a binding agreement, and they wouldn't have taken this position that they are now unless they had gotten a better deal and then decided to try and renege on the deal.
Mr. Hosoffel, you are at your time if you want to reserve 5 minutes.
All right.
And I know we took up a lot of that time with our questions.
Well, that's okay. I understand how this works.
Mr. McMahon, you have 15 minutes.
Thank you, Your Honors. I think Your Honor's questions to counsel go to the heart of this case.
Let me start by asking you a question then too. Why isn't Mr. Hosoffel right that there is an offer of $400,000 and an acceptance? The language was very clear in that email back. My client accepts your offer. Why isn't a contract formed at that very moment?
Well, there's a number of reasons, Your Honor. I'll start with the language of the emails. As you and Judge Bergeron pointed out, I mean, these are not, even though Mr. Hosoffel claims the entire contract is found in 2 emails, he cherry picks, is the term we use in our briefing, language out of these series of emails to claim that only this part or this part forms the contract.
But I want you to focus only on emails up until the time that they say the offer is accepted. Because if a contract is formed then, anything after that it is maybe irrelevant.
I agree with that, Your Honor, and that's what I was getting to. As Judge Bergeron pointed out, one of Vicki Blackman's emails back, one of several, was on December 5th, and she had other emails where she talked about the required contract form that needs to be signed. Here are the due diligence materials. Here is the form contract. You're required to pay the buyer's premium. As you pointed out several times,
was the form contract included in the materials she sent over to him or gave him access to?
Yes, and it was also included in the electronic Dropbox that was provided to him. And he admitted under oath on cross-examination as having reviewed the due diligence materials. He may not have paid attention to it, but as Judge Myers pointed out several times to counsel, every email that Vicki Blackman sent to Joe Vogel had that legend that Judge Myers cited. Every single one.
But it is
It just makes no sense.
But
Sorry.
it is after the signature, even though I pointed out it was in a black box, it is after the signature where oftentimes law firms and other companies have all of their disclaimers that realistically most people don't read. If it was so important, why wasn't it in the body of the email?
Well, what I would say, Your Honor, is it's not after which signature. When you have a chain of emails that supposedly form the
It's after
contract.
her signature every
I know,
time.
but in a chain of emails that supposedly form a contract, that legend is both before and after every signature.
So
It is found in that series of emails.
Is it your position that that language precludes any formation of contract by email for real estate transactions?
It's my position that it precludes the formation of any contract for the sale of real estate in this transaction. No, I understand under measure, which I know Judge Myers.
Well, let's just assume that the contract is spelled out in more detail than in this case. And it's like, I offer $400,000, all these details. The response back from Ms. Blackman is, we accept, we agree on all those terms. But there's that language at the bottom of it. Is there a contract there or not?
No, absolutely not. And it's not just that language. It's also the authority that Ms. Blackman has.
So your
as the owner of the
position is,
property, I'm sorry.
I'm sorry. So let me just quickly follow up. So your position is that Mr. Hosoffel's client could back out under those circumstances, and he wouldn't be
absolutely.
bound by his offer and your client's acceptance.
Absolutely, there was no signed deal. I mean, let's go through this. I mean, my client negotiated a very specific deal with Williams & Williams. They were required to use the form written contract that he hired local counsel here in Cincinnati to help draft, negotiate, and write up to protect his interest. They were required to use that form contract.
Well, but
Mr.
Mr.
Vogel-
Albee doesn't know any of that.
Mr. Vogel was told that.
I mean, Mr. Vogel.
Mr. Vogel was told the terms and conditions of sale that were posted and made available to him and sent to him explicitly said that the form contract has to be used. And he was told that also in emails from Ms. Blackman, which, if you want to call them counteroffers, ongoing negotiations, whatever you want to call them, this is the normal course for events between a representative of a real estate agency in Oklahoma and a prospective buyer. My client, as he testified and as Vicki Blackman testified, only my client had the right to accept any offers and sign the contract. My client has been doing business.
Well, but isn't there an apparent authority issue? I mean, she's your agent. You know, to Judge Myers' question, like Vogel doesn't know any of that.
Well, yes, he does, because it's told there in the legend, and it's told in the body of the terms and conditions of sale. He is told on multiple occasions that he has to sign a separate form written contract in order for there to be a deal. He has expressly told that repeatedly. And as Judge Myers pointed out, the legend on every email that he received from Vicki Blackman says, hey, yeah, if we negotiate some terms and there's like a contingent agreement of some kind, nothing's binding until the actual parties sign the form written contract.
So if he just decides he doesn't want to sign it because the sky is blue, your position is your client has no recourse and there's no deal?
Oh, absolutely. There's no deal until there's a deal. And there's no deal in this case.
That's a circular argument.
Well,
You mean there's no deal until there's, Mr. Hosoffel's position is there is a signed written contract. It's the emails. Your position is there's a specific form of contract that needs to be signed.
Well, yes, and that's the finding by the trial court, is that the parties did not demonstrate their intent to form a contract. And the evidence overwhelmingly supports that finding by the trial court.
Aren't some of the later emails, doesn't your client say that he had a deal with Mr. Vogel?
No.
I'm paraphrasing, but accepted his offer and, implying that there was a deal?
Well, there's an agreement to enter into an agreement, if that's a way to put it. This is what happens in real estate, as everyone on this panel knows, as Mr. Holzoffel knows in dealing with these transactions. Agents might negotiate prices back and forth, but it's up to the parties who have the power to sign contracts and bind themselves to actually sign the document. Mr. Holzoffel talks about the Electronic Signatures Act. Mr. Vogel didn't even know that existed on December 7th. How could he possibly have an intent to use emails as a contract when he said, A, he never heard of that statute, B, he didn't know an email could be a contract, C, he intended at all times to physically sign a contract. So his intent is out the window. It's legally and factually impossible. And that's exactly what my client testified to. He has done business for 30 years in some form or fashion. He has signed hundreds, if not thousands, of contracts. He negotiated the specific form contract for reasons to protect his interest. And Ms. Blackman was authorized to bring prospective buyers to him, to bring offers to him that are packaged appropriately on the form written contract along with the down payment, tender them to him, and he could sit there and say, okay, I don't like this one. I'm thinking about this one. No, this one's out. And he'll sign the one that he wants. And he said at all times, he intended to physically sign the form written contract. And that's precisely what Vicki Blackman testified to as well. At no point was she ever authorized expressly or by any implication to sign an agreement or to enter into one on the owner's behalf. Unlike Measure v. Schrand, those were the principals negotiating directly with each other. And this court found the intent of the parties as to whether the emails will constitute a binding contract or whether they will have to enter into a separate contract is a question of fact for the trier of fact. Well, the trier of fact made that determination. And the trier of fact, as I noted, expressly found that the parties did not have any intent to enter into this contract. And I don't know how much time I have, but I do want to talk about our counterclaim as well.
Because, you have 6 minutes.
Okay, thank you. As I was going to start off before your questioning, this lawsuit never should have been filed. I mean, Mr. Vogel and counsel knew he did not have a contract. Mr. Vogel, as he says now, the attorney, his attorney had to approve this.
I hear what you're saying, but there is certainly a dispute, and I think it's a dispute in good faith as to whether there is a contract. And to me, it looks like both parties behave strategically to do what they thought was in their best interest, even when that meant taking inconsistent positions. So, I mean, and he has a legitimate point that you guys wanted, got a better offer, and suddenly you wanted to use that as an escape hatch. So I'm having trouble seeing how this would rise to the level, even if we agreed with you otherwise, to something that would sustain a counterclaim.
Well, what Mr. Holzapfel was referring to is communications at the end of the day on Friday, December 7th. There was no contract with the other buyer as of Friday, December 7th. Mr. Vogel wasn't told until December 17th that another buyer had signed a contract with the seller. Vicki Blackman was reaching out to Mr. Vogel and Mr. Holzapfel late on December 7th, on December 10th, 11th, and 12th, as to whether they were still interested. Mr. Vogel on I think it was the 10th or the 11th, said by an email, I don't know what my attorney's doing, even though he's supposed to be reviewing this contract and approving the deal. On December 12th, Mr. Holzapfel himself sent an email to Vicki Blackman saying that he represented a party, Joe Vogel, who was interested in buying the contract. No one said we already have a contract, that was formed 5 days earlier. So while Your Honor, Judge Bergeron, you might think that the parties demonstrated good faith in doing what Mr. Vogel did, that only goes to the frivolous conduct counterclaim. The trial court expressly found in my client's favor on the action to quiet title. And I think by doing so, the trial court essentially recognized that there was a cloud on the title. And we have a slander of title counterclaim that we met all the elements in the evidentiary record. We also have tortious interference with contract and business relationships claim in the counterclaim. Again, we proved every element of that cause of action, or those causes of action, I should say, at trial. And our damages evidence was, for all practical purposes, uncontested. I mean, we put on the evidence about my client losing the deal, which was the whole purpose of them pursuing this matter, threatening to file suit, filing the lawsuit. They stopped my client's closing from happening. That was their objective, and they succeeded in that regard. And by putting the cloud on title, which my clients could not remove in a timely manner, it led to that deal falling apart. As a result, to this day, my client still owns 318 West 3rd Street. And in the counterclaim, we sought and put on evidence that's uncontested about the carrying costs for losing that sale, for continuing to own the property, of $15,976.60, and the loss of use of the $452,500 that my client would have gotten because the property has no debt, no mortgage. They would have been able to get and invest over $452,000. And my client's testimony about his expected recovery or income, I should say, earnings.
And he would have invested that in Amazon stock, right?
Excuse me?
He would have invested that in Amazon stock, right?
Well, I wish, but what he testified to is that he had earnings of approximately 8%. He's not seeking 15, 30% or some astronomical return. It's consistent with the market and what he testified to from his mutual funds for the 1 year period after losing this deal. So all told, we put on uncontested evidence about $52,176.60 in damages, which my clients lost as a result of the slander of title and the tortious interference with this deal. I'm sorry, Judge Myers.
I was just going to ask, just out of curiosity, it really has no relevance to this case, but in mitigation, did Mr. Hosoffel try to enforce the existing contract that he claims exists and have the property transferred to his client other than through this lawsuit?
I'm not sure if I understand your question, Your Honor.
Well, you said he lost the sale. Mr. Hosoffel's position is that there's an enforceable deal to sell the property to his client for $400,000.
Oh, sorry.
I'm just
that is his
curious.
position. That is his position. But based on the trial court's finding, the evidence and the law, he is flatly incorrect.
All right. And you are at your time.
Thank you, Your Honors.
Mr. Hosoffel, you have 5 minutes, and let me start by asking you a question. Your position is that as of December 7th, when the email came that says, and I'm paraphrasing, but my client has accepted your offer, that there was a binding contract with the only contingency being in favor of your client, which is that you had to approve the deal. And am I right so far?
Yes, ma'am.
All right. Now, later, there were some emails from you talking about an inspection. And my question really is a hypothetical, but let's say that there was an inspection on the property and that it found some terrible environmental problem with the property. I assume your position is, for your client, tough because we had a binding contract on December 7th and my client couldn't have gotten out of the contract at that point.
That is correct. There was no inspection contingency in the contract. I was mistaken. I wrote a letter after the fact. I didn't have all the emails, and when I had all the emails on Exhibit 20, I wrote a letter setting forth the fact that we had a contract and that there was no inspection contingency. And if there was a problem, that was my client's problem. In fact, Albee testified that there were no contingencies of any kind in the offer. Page 391 of the transcript. They are turning contract law on its head.
Let me ask you a follow-up question to that. I see nothing in these emails about what kind of title is to be conveyed. So what kind of title, if any, is to be conveyed under these circumstances?
Well, there is not that term. They have to convey title. And since it was not part of the contract.
But what if there's some encumbrance, some lien on the title, and they just transfer a quitclaim deed and say, tough luck?
Then That's the contract my client entered into. If there was a problem with the property, that's his problem. He made a 4-part offer. It did not include any of the boilerplate stuff that you see in contracts. And parties are free to contract. And what I don't understand is that when he makes a 4-part offer, they acknowledge that those are the 4 parts of the offer. They acknowledge they communicated that to Albee. Albee acknowledges that he accepted that offer. If Albee wanted to include this boilerplate stuff that's at the bottom in small print, that box around it or not, that says, he should have done so. He should have said, we will, okay, tell Vogel this. And he authorized his agent to deal with it. And the trial court found that the agent had the authority to bind Albee. He didn't want to talk to these people. That was his decision. But when the ball was in his court, here's this 4-part offer. Do you accept it or counter it? He could have countered it and said, tell Albee or tell Vogel that we like the price, but he's got to do A, B, C, and D. That makes it a counter offer. Then the ball is back in my client's court, and he has to accept whether he wants to add A, B, C, and D to the offer. Albee never did that. He told his agent to tell Vogel he was accepting the 4-part offer. And look at Exhibit 25. You talk about admissions against interest. An Exhibit 25, an email that Albee wrote himself. He says, understand, I accepted Vogel's lower offer. Understand, I accepted it. And the only excuse he gives after the fact is he says, Vogel wanted to include an inspection. That changed the offer I accepted. Twice he admits that he accepted Vogel's offer. And then he found out later that the inspection contingency was in another offer, not in Vogel's offer. There was no inspection contingency. This is the deal he wanted to make. Parties are free to contract. They can be stupid about it. They can be really smart about it. This is the deal. He wanted the property. He really wanted the property for the wall so he could put a billboard on it. He didn't care about the condition of the building so much. He really was buying this property for the huge wall to put a billboard on. So it wasn't important to him. And apparently it wasn't important to the seller. And you have to let these, I'm sorry.
It's following up on Judge Meyer's question about the contingency for an inspection. There's an early email, it looks like on December 7th, from Blackman, Albee, and Jansen. And it says the buyer also wants to schedule an inspection on the property. I will get back to you on a date and time. Now, it's not clear which buyer is being referred to. I don't know whether it's your client or the ultimate, well, I thought nobody purchased the property, but the other party, Loring. Then Mr. Holzapfel on 12/12, your email to Ms. Blackman says, dear Ms. Blackman, I represent Joe Vogel, who is interested in purchasing the above referenced property subject to an inspection. Who do I contact to obtain access to the building so that our inspector can take a look at it? Now, you've indicated that there was no inspection contingency in the contract. What does that email mean then?
That's right. There was no inspection contingency. And when I wrote that letter, I didn't have the emails in front of me. I thought it'd be a good idea to inspect the property, but
I agree.
It was not part of the offer, and it wasn't part of the acceptance. And this is, to me, this is the key of this whole case. If acceptance meets the offer and there's no inspection contingency, then that's not part of the contract.
And Mr. Holzapfel, you are at your time.
Okay. Thank you for your time.
Counsel, thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion.
Thank you.
Thank you, Your Honor.
Thank you. Next case on our docket this morning is Ayer versus Morenz Harbinger. And counsel, let's begin with counsel for appellant. If you'll introduce yourself and indicate your readiness to proceed.
Good morning, Your Honor. Jeff Nye. I'll be arguing on behalf of both of the appellants today. I am ready to proceed, though I understand that one of the appellants, Mark Ayer, is in a waiting room. I don't know if anyone can let him in before we get started here today.
I show that he's in the Zoom. At least we have in our gallery view somebody named Mark Ayer.
Okay, I just, okay, I don't know what else to say.
I mean, I don't know, but
yeah,
it's showing up.
Okay.
All right. Thank you, Mr. Nye.
Your Honor, Brian Sullivan on behalf of the appellee, Deborah Lynn's Morenz Harbinger.
Mr. Nye, of your 15 minutes, would you like to reserve any time this morning?
3 minutes, please.
All right, whenever you're ready.
Okay, good morning, Your Honors. We're asking you to reverse in its entirety the visiting judge's summary judgment decision and remand this case for trial in the probate court. I want to talk first about the validity of the will and then move into undue influence and capacity later, but of course, please jump in at any point if you want me to talk about something else. This is a will contest case, but really it's a civil procedure case. It's a case about who decides. When the only two witnesses give conflicting accounts of an event, what do? I mean, here you had one witness, Lou Seiler, say that there was an eyewitness attestation. He said that Ms. Ratterman, Ruth Ratterman, signed her will in Doris Barrett's presence and his presence. He said, we all signed it together. That's on pages 31, 34 of his deposition. But the other witness, Doris Barrett, says there wasn't an eyewitness attestation. She says, I didn't see Ruth sign nothing. No. Who decides which version of the facts?
The question was never asked to her whether the signature was acknowledged in her presence. So she could maybe have not seen the actual signature, but if it was acknowledged to her, then the will's still valid, right?
Right. And so if that question was asked, we could present that evidence and the court consider it. The evidence isn't in the record. The evidence isn't in the record, right?
Well, but my question is, like, is there an actual conflict, or is there just a gap in the evidence which would then be resolved by virtue of the clause in the will that says that it was acknowledged?
Okay, so you've got three pieces of evidence. You can pick any one of them and it's conflicted by at least one of the other accounts, right? So if you want to say, well, the clause on the will says that there was an acknowledgement, well, Lou Seiler says, no, we all signed it together. That describes an eyewitness attestation, not an attestation by acknowledgement, right? Especially when you view the light in the evidence most favorable to the non-movements. He's not saying she acknowledged a previous signature on the document. He's saying we all signed it together. That's observing the testator sign the will. That's an eyewitness attestation. If you want to look at, if you want to start with Seiler's testimony, his testimony of an eyewitness attestation is conflicted both by the clause on the will that says acknowledged in our presence and by Doris Barrett, who specifically said, I did not see Ruth sign that. And this was the issue in the Timberlake versus Sayre case, which we cited on pages, I think, 26, 27 of our brief. It's the only case that really presents this fact pattern that either party cited. Now, that was a legal malpractice case. So you've got sort of the case within a case doctrine where you have to look through the underlying case to see if you can establish the causation element of your legal malpractice claim. But the underlying case there was a will contest under 210703. And so the court said, all right, we got to look at that evidence. What was the evidence about how the will was attested? And you had two alleged witnesses, people named Bricky and Tackett. And Tackett says, yes, we all signed the will together. And Bricky says, I did not see the testator sign the will. The court said, well, look, yes, Judge.
I'm sorry, Mr. Nye. But under either, let's say there is a conflict. Isn't the will valid no matter which fact pattern is accepted?
No, because there must be evidence that establishes one of them happened. Now, absolutely, a jury could conclude that either we believe the attestation clause or we believe Lou Seiler, but no matter which one you start with.
But getting back to Judge Meyer's question, like, so if the jury believes Lou Seiler or the jury believes the attestation clause, you lose. And so what would the jury believe from Ms. Barrett that would be inconsistent with that and would say you win.
Right. So if you start with Lou Seiler, he says we all signed it together.
Right.
View that evidence in the light most favorable to the non-movants. That's evidence of an eyewitness attestation, right? That is conflicted both by the will, which says acknowledgement, and by Doris Barrett that says there was not an eyewitness attestation. So you've got three different versions of the facts there.
But so what? The will's valid under any of those. If
It
Ms.
requires you-
Barrett didn't see or sign, but it was acknowledged to her that she did, it's still a valid will.
The only way to reach that conclusion is to ignore Lou Seiler's testimony that we all signed it together. That is
No.
evidence.
I don't think that's what I'm saying. Maybe I'm not being clear. For summary judgment, it's not only that there's a genuine issue of material fact, it has to be, and the movement is entitled to judgment as a matter of law. Under any version of the facts, isn't the movement entitled to judgment as a matter of law? Because the will is valid under any of those conflicting factual scenarios.
No, if there is a factual scenario where there is not an attestation by acknowledgement because it's conflicted by Lou Seiler, and Doris Barrett says, I don't know that there was a signature on the will. She is saying, it was not acknowledged to me. If it was acknowledged to her, she would know that there was a signature on the will, and it's also conflicted by Lou Seiler. So you cannot rely on the attestation clause. That's conflicted by two separate pieces of evidence. You also cannot rely on Lou Seiler's testimony because it conflicted, again, by the attestation clause on the will itself, and is conflicted by Doris Barrett. Again, this is exactly what happened in the Timberlake case, where the court said,
I'm sorry to interrupt you, but I want to make sure I understand.
Yeah.
So your position is that the will could be invalid because a trier of fact could believe that Ms. Barrett didn't really either see or sign it or have it acknowledged.
there are only two living people who were in that room, and they give conflicting versions of the events. The only way to decide that is to believe one and not believe the other. You can't do that on summary judgment. Again, this is what Timberlake said. They said, the Timberlake court said, not only is there an issue of fact, but the Timberlake court actually said the will is invalid. There is no way to believe one without conflicting with at least one piece of other evidence. That's the holding of Timberlake. I think in response to this, what Debbie says is, well, there's a presumption of validity, and that's true, but that only applies if there is no countervailing evidence. Again,
I'm not sure I still understand. So let's say the trier of fact believes Mr. Seiler, then the will is valid. Let's say the trier of fact believes Ms. Barrett, then the will is valid. When does the will become invalid?
No, if the trier of fact believes Barrett, the will is invalid. She says, I did not see.
But why? Because she didn't say it's not my signature, and she didn't say I didn't hear what's the word I'm looking for? An acknowledgement.
Yeah.
By I'm blanking on the names, but you understand what I'm saying.
Yeah. So what she said was, I did not see Ruth sign the will. I did not see Seiler sign the will. And when I got up there to sign it, I don't know that it had already been signed. That's pretty clear testimony that there was certainly no eyewitness attestation, and there was no acknowledgement. She says, I don't know that Ruth signed it before I do. She's not saying I have a faulty memory. She's saying, I don't know. I didn't see the signature. I was not there when it was signed. Again, a trier of fact could believe or disbelieve that evidence. But if you view it in the light most favorable to us, the only way to view that is to conclude that it was not acknowledged to her. Otherwise, she would know that Ruth's signature was on the will before she signed it. She says on pages 40 and 41 of his deposition, that's not how it happened. So if you believe her testimony, the will is invalid. I'm not asking this court to believe her testimony. I'm just asking to let a jury decide. That's the purpose of a jury. That's not something we can do on summary judgment. And the court below erred when it did that. Again, that's the holding of Timberlake.
Mr. Nye, let me ask you a question about the execution of the will. Ruth called her friend down. She called and said, "Hey, I want you to come down and witness my will. I'm leaving everything to Debbie." And she goes down and she did identify her signature as a witness on that will. Are we permitted to take in the facts and circumstances surrounding the execution, or do we just have to look at one, whether Ruth signed the will in Ms. Barrett's presence or acknowledged her signature on the will?
It's
You understand the question?
I'm sorry. Were you...
No, I'm finished.
Okay, sorry about that. It's the latter. There are some cases in the briefs that sort of rely on the facts and circumstances theory, and I'm not sure that we did an adequate job explaining this in the reply. Those are all either not summary judgment cases at all, or even will contest cases. So in Ray McGraw, for example, Taylor versus Geringer, and the Blagg case, which I think is the one Debbie primarily relies on, Blagg is not a will contest. It's an application to admit a will to probate. That is a completely different legal issue. All you need there is a prima facie case that a will is valid. And so the court said you can look at the facts and circumstances and say, yeah, there's a prima facie case that there's a valid will. That is not the same as a summary judgment that a will is valid under 210703. The elements of the statute are clear. You have to satisfy all of them in order to have a valid will. Again, not the same as admission of a will to probate, which is not an adversarial proceeding at all, and from which there is no summary judgment.
And Mr. Nye, you have about 2 minutes left.
Oh, good. Okay. I guess I'll take just a couple of minutes to quickly talk about capacity and undue influence. A couple of points about this. The evidence here moves in the same direction, so it overlaps to a large extent. Again, here, we kind of got upside down on this issue below. Debbie argues that there isn't evidence of undue influence, but because she was in a position of trust or confidence with respect to Ruth, there's a presumption of undue influence. The question isn't, whether there's evidence of influence. The question is whether she can rebut that presumption.
A lot of the cases of undue influence involve the beneficiary basically steering that the person to a particular lawyer, being in the room with them. In this case, she hears about the lawyer from someone totally independent, has conversations with the lawyer without Debbie present. I guess what is your best evidence that Debbie actually perpetrated some undue influence in connection with the will, and not focusing on what happened afterwards, but leading up to the execution of the will?
Yeah, sure. A couple points on that. One is that I think it's a mistake to focus solely on the time period leading up to it. If you look at, for example, Knowlton versus Schultz from this court about 10 years ago, the test is to look at a reasonable period before and after the execution of the will. We see both the experts agree that at this time she's suffering from untreated depression and anxiety and so on, so we know she's susceptible. What we actually see, though, is that the first will is signed in April of 2014, at a time when both Mark Ayer and Evelyn Ratterman saying they're seeing Ruth and Ruth Lest, and Debbie starting to take over her affairs. But then within about 2 months after that, in June, both Debbie and her husband, who is a lawyer, are the ones communicating with Lou Seiler on Ruth's behalf to say, hey, you need to revise this will. You need to revise this power of attorney so Debbie has gifting authority that she then uses to essentially gift several $1 million to herself. So you look at a reasonable time before and after, and especially in light of the presumption of undue influence that arises here. I think my best case on this is probably Holden versus Holden from the 12th District from last year or the year before, which I know is cited in our brief. You look at a reasonable time period before and after that, and the presumption of undue influence arises. I think I'm out of time, so I'll reserve the rest of it for rebuttal.
You are out of time. Thank you, Mr. Nye.
Judge, do you want me to turn my camera off at this point, or?
No, you don't. You don't need to.
Right.
Mr. Sullivan, you have 15 minutes.
Thank you, Your Honors. I'll start with the points that Mr. Nye ended with, and that is the undue influence and the capacity. This case, unfortunately, has been almost like the proverbial whack-a-mole, in that we keep chasing allegations that have arisen over the course of this lawsuit. The very origins of this case were that Debbie orchestrated this meeting that Ms. Ratterman had with Mr. Seiler, that she controlled the meeting, that she controlled the meeting because Mr. Seiler was in practice with Debbie's husband. All of that is completely false. It then evolved to, well, there's the susceptibility issue because she was under depression. I challenge Mr. Nye in his rebuttal to identify a single witness who brings forth any evidence that she was susceptible or that Debbie exerted undue influence. In fact, every pro se defendant that was sued in this case, who knew Miss Ratterman as well as anybody, from her sister-in-law, Evelyn Ratterman, who knew her for more than 50 years, to her nieces and nephews, all filed pro se answers to say she was not under undue influence. She knew exactly what she was doing. There was no confusion in her state of mind. And the appellant's brief got it wrong when they say the trial court found that there was susceptibility. That's not what happened. The trial court said of all of the issues, the only one that you even have any evidence on is susceptibility. As we well know, that's not sufficient to overcome summary judgment. That
Mr.
dovetails.
Sullivan, may I ask you a question about the execution
Yes.
of the will issue?
Mhm.
Even though the evidence might seem to favor your client, assume that in terms of execution, isn't there a question of fact about whether the neighbor properly either saw her sign or had her signature acknowledged, and therefore the trial court's not permitted to make a judgment about the facts, and neither are we?
The answer to that question is no, Your Honor. If you look at Ms. Barrett's testimony, and the pivotal question that they did not ask, but her answer on page 41 was, do you know if Ruth's signature was on the document when you signed it? Her answer was, I don't know. That's on page 41, lines 3 through 7. That does not create a material issue of fact.
Are you saying that she would have had to answer no to that question to create an issue?
In order to overcome to meet their claim where she did not acknowledge, she has to say, no, I did not see her signature ever on the document. What she testified was, I didn't see Ruth sign it, which, obviously Mr. Simon.
Were there any questions about acknowledgement?
No, there were not. That's the issue here, is they didn't bring forth any evidence to say, did she acknowledge this is my signature? In fact, everybody agrees the purpose of that meeting where the three of them found themselves in the same place was for the purpose of Ruth preparing, executing, and for them to witness the will. They all agree to that. Mr. Seiler said that he heard Ruth called Ms. Barrett to come up. Ms. Barrett said she was called up to witness a will. And in fact, if you jump way ahead, after 3 years later, after the will was signed, Mr. Mark Ayer called Doris Barrett and said, hey, did you witness Aunt Ruth's signature on her will? And she said, yes, I did, because she wanted to give everything to Debbie. So there is no disputed issue of fact that they can present to a jury that says, well, you can disbelieve one because you believe the other. Now, to your question, Judge Winkler, there are the facts and circumstances here that are overwhelming in the favor of why this will should be upheld. If you go back to the meeting, she was called by Miss Ratterman, by Evelyn. That's the way she found Mr. Seiler. He came out to her house. They went through this whole litany of all of these questions, but she identified the nature of her bounty. She identified who she related to. She identified 15 specific requests she wanted to make. Clearly a woman of sound mind. She wrote in her entry in her diary that night that she executed a will. She wrote the check made payable to Mr. Seiler for $400 that day. And her accountant, of course, testified unequivocally that she knew what she was doing. So when you get to what happened during that meeting, she identifies every single thing. Mr. Seiler prepares a will. Pivotal question, the $300,000 notation. They believe that's all she had. Well, that clearly is not corroborated by anything, because the pivotal question to Mr. Seiler was, did she tell you that's all she had? Or did she tell you that's just the value of one of her assets? And he answered on page 28, I don't remember which one it was. Now this is
didn't he say that if he had appreciated that the estate was of the size that it actually ended up being, that he would have referred her out to someone else? Doesn't that suggest that he didn't have a firm grasp on what was in her estate?
He did ask those questions, but there is no law that says the lawyer has an obligation or that the client has an obligation to fully disclose to the lawyer every single asset he or she might own. You just have to know the general extent of your bounty. And the fact that she identified all of those accounts in his written notes indicates she knew what she was, what her bounty was. And, she did her own checking. She did her own information for the account. So she knew the extent of her bounty. There's no law that says you're required to prove capacity by disclosing to the lawyer every single thing you own. So there is no issue about the capacity. And then that dovetails into the final piece here, and that is the circumstances surrounding the execution, of which Mr. Knight spent a lot of time on. Again, they all agree the will was prepared. Mr. Seiler went over and made sure Ruth understood this is what she wanted. He's one of those old-fashioned lawyers who makes house calls. He printed it out, she read it, then that's when the call was. And they all agreed to the circumstances, why they were there, the fact that she was asked to witness the will. She testified that the lawyer told her where to sign. She testified on page 25, or page 12, I read where I signed it. So she knew she was executing as a witness. She had testified that that was her signature. She testified that that was her handwriting for where her address was. So there's no dispute then as to how you get to the acknowledgement. 210703, remember, provides alternatives. You can have an acknowledgement, or you can see you saw it. Either one makes the will valid. The fact that she signed her name to a will that she knew Ruth prepared and she doesn't remember Ruth's signature on it does not create the issue of fact that gets submitted to the jury. And that's the basis here of why summary judgment should be affirmed, because there's only two people and they do not materially disagree as to the facts that occurred on April 8th, 2014. And what Mr. Nye wants you to believe is disbelieve one. And as Judge Myers pointed out, this still doesn't get you anywhere. The will is still valid, either one. If you disbelieve Ms. Barrett, if you disbelieve Mr. Seiler, the will is still valid on its face. I think that's what I have. The last point I will make is the law does not require an attestation clause. The law does not require the two signatures be on the same page as the testator. The law clearly does not require that the lawyer be the witness. All of those, to Judge Winkler's point, are facts which go to the heart of the issue here, and that this was a validly executed will on April 8th, 2014, should be affirmed. Summary judgment should be affirmed so that Ruth's true intentions, as she expressed to her lawyer through her will, should be carried out. Thank you.
Thank you. Mr. Nye, you have 3 minutes remaining.
Thank you, Judge. I think I want to make about 3 points in reply. A lot of what I heard in that argument is the same thing we saw in the briefs. It's an express invitation to this court to weigh the evidence. The brief used the term weight or outweighs or how substantial the evidence is a whole bunch of times. And some of that argument we just heard is, well, you can believe one or you can believe the other, and that there's overwhelming evidence in support of an issue. Those are weighing words. Those are great arguments to make to a jury. Those are.
Well, let me ask you this. What is your argument that you make to a jury? Let's assume the testimony is exactly as it is on the issue of whether or not there was valid execution of the will. What do you tell the jury you should believe Ms. Barrett and that craters the will? How do you explain that to the jury?
How do you explain it to the jury? So you look at pages 40 and 41 of her deposition. If that's how she testifies at trial, she says, I did not see Lou Seiler sign it. I did not see Ruth sign it. I don't know that the signature was on it. Lou Seiler says, we all signed it together, so we know from his testimony that it was not previously signed when Doris Barrett got up there. This is not something that she does every day. This is an event that she would remember. Lou Seiler, good lawyer, been around a long time. He's probably done thousands of wills. Maybe he forgot this one.
If I'm on the other side, though, don't I argue that they're not inconsistent, that everybody was up there together? So I believe Mr. Seiler, we all signed it together, meaning we signed it at the same time. Maybe Ms. Barrett didn't exactly see her sign it, but we're all up there with our pens and, going around the table as often as done. So maybe Ms. Barrett is witnessing it while the testator is signing something else. I mean, are those really inconsistent?
They are in two ways. One is what you said is, don't I ask them to believe Seiler? Yeah, that's what they ask a jury to believe it. That's not something you can do with a judge on summary judgment. The other thing is that the law requires you to either see the testator sign. So if you're over looking out the window, that's not good enough, or hear the testator acknowledge. There's no evidence whatsoever in the testimony that either of those things, that the latter happened. And Ruth and Doris Barrett explicitly says that the first didn't happen. She said, I didn't see it. Lou Seiler says, yes, you did. Neither one of them says it was acknowledged. So there's no way to reconcile that without weighing the evidence, determining one is more credible than the other, and making a conclusion of fact. That's not something you can do on summary judgment. I know my time's up, so unless the court has any other questions.
You actually, at least by my count, have 1 minute left if there's any last point you'd like to make.
Yeah, what else do I want to say? Oh, there's so much I'd like to say. The other point, do they really materially conflict? Again, this is the Timberlake case. The court says when one witness says, as Lou Seiler does, we all signed it together, and one witness says, no, we didn't, those are directly conflicting. Again, that's just ordinary application of Rule 56. There cannot be a telephone acknowledgement. There cannot be an execution by the testator after the fact. The signature had to either be on the will when Doris Barrett got up there. She says on page 40, she didn't see it, or it had to be signed. She had to see the witness sign it. She says, I did not see Ruth sign it. Again, you are
now out of time.
Right. So you can believe either one, but only a jury can decide that. So we're asking the court to please reverse the summary judgment and remand for trial. Thank you.
All right. Thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion.
Thank you, Your Honor.
Thank you. And the final case to be argued today is State of Ohio versus Donald Williams. Give everybody a chance to get out. I think they all are. All right. Ms. Peters, I see you on the screen. On behalf of appellant, would you like to introduce yourself and indicate your readiness to proceed?
My name is Laura Peters. I represent the appellant Donald Williams. I am ready to proceed.
All right. And Ms. Steer?
Mary Steer for the state, ready to proceed.
Thank you. Ms. Peters, of your 15 minutes, would you like to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes, please.
All right. And whenever you're ready.
Okay. May it please the court. My name is Laura Peters. I represent Donald Williams in this matter. I'd like to start with discussing the first assignment of error. This court needs to go no further than the decision it issued last week in State versus Parish, in which this court examined the new burden shifting self-defense statute. In that case, this court stated that the burden of the defendant no longer has the burden by a preponderance of the evidence to prove self-defense. Rather, they have the burden of going forward with producing some evidence that tends to support that self-defense was applied in this case.
So are you saying that pulling earbuds out tends to support self-defense, or is there something else?
Well, yes, Your Honor. She claimed that she stated that she swiped the earbuds out of his ears, and that his response to that, if it was that he pinned her to a bed. So he held her arms down and he prevented her from any further attack on him. She then, but it was able to wrestle him to the floor, and they engaged in a fist fight. So his actions were all done in response to her. So she initiated any physical contact. So he put his hands on her to keep her away from him. And then she wrestled him to the floor and engaged in a fist fight. So his response, so he responded to that action. So yes, I would say that there is evidence that tends to support that Mr. Williams acted in self-defense. And as this court stated in State versus Parrish, when looking at the evidence as to whether or not the state needs to prove beyond a reasonable doubt that he did not act in self-defense, that the evidence must be construed in favor of the person claiming self-defense. So if you look at it, she initiates the physical contact by forcibly removing earbuds from his ear. She then
but like that happens with my kids all the time, and I don't think that really is sufficient to precipitate a physical attack.
But his response was not much more than what her initial physical is, that he pinned her to a bed. She doesn't claim that he was punching her at that time, that he was choking her at that time. She said he had her arms and she was pinned to the bed, and then she wrestled him to the ground and proceeded to engage in a fist fight. So I would say that when you're construing the evidence, and her testimony is enough to show that there was a tendency to show that he was acting in self-defense. And we also have to consider the officer's testimony here, where while that she claims that there was this engaged fist fight where he was choking her and punching her in the face, the officers also could not detect any physical injury on her when they first saw her. They could on Mr. Williams, that his injuries were readily visible, but not on her. She had to be placed under a light to see a scratch on her cheek. Now, what she claims later on happened that 2 days after this incident, that's when her jaw began to swell and she couldn't eat. And she somehow manufactured photos that were taken. The earliest was taken, she claims, on May 5, and then there was other photographs that were taken much later. But her testimony is incredible. There's also other indications why her testimony isn't credible.
Well,
and
how do we know that the trial court did not apply the correct standard?
Because the trial court, when he went from A to C, he went from A to C, he said the ripping of the earbuds out versus what's the injury claimed in the exhibits. But there's steps involved here beyond just the ripping of the earbud and the what was depicted in the photos.
I mean, we don't have any statement by the trial court on the record, at least that I saw, that indicates the court was proceeding under the incorrect standard, do we?
Well, but then, I mean, he's clearly but also by relying on those pictures, he's not viewing the evidence in favor of the defendant, as was stated in paragraph, I believe 14 of Parrish, or 14 or 15, was that you have to consider the light most favorable to Mr. Williams. So if Mr. Williams, the evidence that's most favorable to him is that the only injury she suffered was a scratch to the cheek, not this swelling that doesn't show up mysteriously doesn't show up for 2 days and until after the incident.
Could I go back to your first point?
Sure.
Because provocation, verbal provocation or hitting out earbuds, something that doesn't necessarily tend to show that someone using physical force acted in self-defense, is it? Because there's no need to defend yourself from knocking out earbuds. I think that's kind of that threshold matter. What evidence tends to suggest that he needed to defend himself with force?
The evidence in there is that her testimony was that, I mean, first of all, she was mad because he called her a bitch. So that's the verbal part of it. The physical part starts when she takes the earbuds out of his hand, and his response is, "Don't put your hands on me." That's her testimony. So obviously he says, don't put your hands on me. So she laid her hands on him. She got physical.
But why does he need to use self-defense? What evidence tends to show that he had to defend himself physically from that action?
Now, she ripped the earbuds out of his ear and she put her hands on him. That's what she indicates. So he puts her, so keep in mind that what his response was to pin her to the bed and to hold her arms down. He wasn't punching her, he wasn't kicking her, he wasn't choking her. He just pinned her to the bed. There's no indication that he was actually causing her any physical harm at that point in time. And then you have to move it on to what she did next, and she wrestled him to the ground. She then engaged him in a fist fight. This was really at best, this was a mutual combat situation and not domestic violence initiated by Mr. Williams. So if there's no other questions on self-defense, or okay,
You answered it. Thank you.
okay. So then
let me ask one more question before you move on. Did defense counsel below ever kind of raise the issue of the appropriate legal standard with the court?
Yes, in closing argument, defense counsel said, because at first she said, at first I thought this was just going to be, the mutual combat, where it would be the disorderly conduct because they were engaging in a mutual fight. And the prosecuting witness, Mrs. McNear, readily says she engaged him in a fight. But then, and she goes, no, now this is under the new self-defense statute where because this, there's no question that the new self-defense statute applied in this case, because the incident occurred afterward and the trial occurred after the effective date. So yes, in closing argument, the defense counsel raised self-defense, and so the new self-defense statute would have applied.
Okay.
We'd also like to contend that the evidence is insufficient and that this conviction is against the manifest weight of the evidence. There are a couple points on this one. First, with regard to the daughter, there was actually she only testified that it was possible. So she didn't even testify that she believed he was the father. She just, kind of said, well, it's possible. And then in their brief, the state argues that the putative father, that he could be considered the putative father, and they also then rely on the statutory definition in 3107.01. However, that definition is limited to 3107.01 to 3701 or 07.19. And it makes sense to limit that because that's the adoption statute where it deals with the putative father registry. And also putative father is defined in the ways of a lot of knots. The person is not married to the mother. The person has not adopted the child. The person has not been, there's been no court proceeding, nor there has been any formal acknowledgement pursuant to certain sections.
But didn't he admit that he lived with her? Doesn't that get them over the hump of cohabitation?
He said he lived with her, but it was for less than a month. And in State versus McLaughlin, where the Ohio Supreme Court said that the sharing of family financial responsibilities is not necessarily required, there does need to be more evidence of beyond just the cohabitation, because in that case, the McLaughlin case, they had been living together for over a year. He said he slept there every night. And there was also evidence that he helped decorate and he helped improve the home, so that there was some shared responsibilities. And in this case, there's been no testimony like that, other than that he was living there for less than a month. So just that one fact doesn't necessarily establish that they were a person living as a spouse. I think you need to go back to Williams and look at all the different factors. So McLaughlin just made clear that no, you don't have to have shared financial responsibility in order to establish this element, that there are other things, it's just one factor. But in this case, you don't have any testimony about any factors, and those, include provisions of shelter, food, clothing, utilities, commingled assets. She talks about it actually, that it was her room, her bed. He actually had a different room in the apartment. So it's not necessarily that they were actually sleeping together. So I would say that the state has actually failed to prove the evidence that she was a person living as a spouse, and also that there was an evidence that the child was his natural child, because there's been no testing of that. And also, as I was trying to say about the putative father registry, because that's worded in the knots. Any man who lived with her could then be, under that definition, would be considered the father of the child. However, you should take, and because that definition is limited to those sections, you should take the plain dictionary definition, and it's reputed to be, generally accepted to be. There was no testimony that Mr. Williams was generally accepted to be the father of this child. So we would submit
you are
that.
at your time, Ms.
Okay.
Peters.
Okay, we would ask this court to reverse. Thank you.
Thank you. Ms. Steer, you have 15 minutes.
Thank you. May it please the court. If I can just start with the first assignment of error also with respect to the self-defense. I think that Ms. Peters and I both agree that what the law is, that the defendant had the burden of production as far as self-defense, and then once that burden is met, then the state has the burden of proof with respect to self-defense. As far as whether or not the defendant met his burden of production of self-defense, I don't think that there's any evidence there. And in fact, the trial courts.
It's from her brief, I thought that the main argument was the yanking of the earbuds, but what I'm hearing today is, well, maybe not just the yanking, it's when there was a subsequent melee, and that maybe that was the genesis of self-defense. So could you respond to that?
Yes, I think that actually this is a good reason why we say that the trial courts are in better position to judge the credibility and to look at the credibility. What I think Ms. Peters is referring to is on page 22 of the transcript, when Ms. McNear talks about Mr. Williams holding her down on the bed. And then she says, the prosecutor asks, so just to clarify, after you were held down on the bed, you eventually, and she says, I tried to, and the prosecutor says, to wrestle away onto the floor, yes. So she wasn't wrestling him down to the floor. She was trying to wrestle away to get away from him. And then it turned into a fight. And although she refers to it as a fist fight in the transcript, I looked through the transcript and at no point does she say that she struck him. And I believe that with his, as far as what
does he say that she struck him though?
I could not, I read through the transcript again this morning, and the only statements we have from him come in through Officer DeFastano. And he doesn't say, all he says is he saw scratches on Mr. Williams. Mr. Williams actually told the officer that it wasn't a physical fight, that it was just a verbal fight. And that's all he said. So I don't think that they met their burden of production. And even if they did, I don't think that there's anything in this record that shows that the trial court didn't apply the new self-defense law, because what he found that there was no self-defense, that they hadn't met self-defense. Like you were saying, Judge Myers, as far as even if you believe that she yanked the earbuds out of his ears, there's nothing to show that it was reasonable for him to have to force to defend himself against any imminent use of unlawful force. There simply was no evidence of that. If she was trying to wrestle away from him, I think she says repeatedly in the transcript, she was trying to get away. She was asking him to leave, and she eventually managed to run out of the room. I just don't think, I think given what we have in the record here, there's no evidence first that they met their burden of production. And even if they did, I don't think that the trial court misapplied the rule. Judge Bergeron, as far as you asking whether or not the defense counsel raised the issue of self-defense, it's on page 60, and she's going through her closing argument, and she says, I think they have the burden to show self-defense, and that was the extent of it. And then the trial court addressed that when he was giving.
I mean, the trial court never said, no, that's wrong or anything like
that. Right. This is unlike in Parrish, where the trial court said, no, it's your burden to show it. So there's nothing like that. If I could move on to the.
Let me ask you, Mr. Steers, I just had a question just to satisfy my own curiosity. The issue of self-defense apparently was not brought up until closing arguments. And I don't know whether it was apparent that that was the defense over the course of the trial, but is there any obligation on the part of the defendant to at least let the court know that they may be proceeding on self-defense? And that's just to satisfy my own curiosity. It sounds like, to me, it sounds like the judge got sandbagged and they brought it up after the trial. Now, I know that the defendant can just sit there, doesn't have to present any evidence whatsoever, but is there any obligation to bring it up and so the court can at least weigh it as opposed to waiting until such time as closing argument?
I'm not sure, Your Honor. I do know that like it's not the same as an alibi defense where that has to be, you know, you have to give your notice of alibi defense. So I don't think that it's anything to that extent. I think in a case where it's obvious that there's self-defense at play, I would imagine that the defendant doesn't have to bring it up. But in a case like this, I think they had to at least do a little more to show where the self-defense was coming in. And even now, it's kind of a moving target where it went from, you know, the earbuds being swiped out of his ears to a fight or wrestling on the bed. If I can move on real quickly to the second assignment of error as far as sufficiency and weight. Again, I don't think that there's any issue about whether or not, I don't think they're raising the sufficiency as far as whether or not he caused her harm. Instead, it's whether or not he was a family or household member. And as I say in my brief, I think he comes in, or she comes in as a family or household member in two ways. Clearly, he was living with her. I don't think there's any time limit. In McLaughlin, there was 1 year, but you don't get a pass for a month if you're just living with someone. And McLaughlin made clear that you don't need the financial support. I think what Williams did, the case before McLaughlin, was trying to find another means to show that you were living with someone when the person isn't always staying at the house. And so another thing you could look at would be financial support. In this case, he was clearly living with her. They were raising their child. He was raising the child as his own. I mean, what started the fight initially was what I would say would be kind of an extreme father's reaction, but a father's reaction when he got upset because the diaper that was on the baby was too small. And that goes to the second way that I think that she qualifies as a family or household member, and that's because he's the putative father of the child. And even if you don't look at the adoption statute, which I think at least gives some indication what putative fatherhood means, even if it's someone who is believed to be or reputed to be the father, he himself told the police officer that he was the father of the baby, that he had a baby there. He acted like a father. She said that he was possibly the father. They don't need actual DNA proof. If they wanted that, it would just be natural father rather than putative father. So I think either one of those elements is satisfied. And unless you have any further questions, I'd just like to submit that the conviction should be affirmed. Thank you.
Any other questions of Ms. Steer? Ms. Peters, you have 3 minutes left.
And Ms. Peters, could you start with Judge Winkler's question about, like, under this new regime, does the defendant have to provide any sort of notice that he's pursuing a self-defense defense, like prior to closing argument, or can you just raise in a closing argument?
No, I don't think that there's any requirement that the defendant give any prior notice. The defendant's obligation is just to make sure that there is some evidence, however it's adduced, whether it's through pointing out and like in this case, the prosecuting witness's testimony shows how, she initiated certain things, or through cross-examination or, other testimony, and then to point it out. And because this is a bench trial, like if it was a jury trial, then obviously defense counsel would have to request a self-defense instruction. But in this case, because it's presented in closing argument, and the judge isn't supposed to be making his decision up. He isn't supposed to say, well, I've heard the prosecuting witness and that's it, that, I've decided I've convicted him. That's not the proper course for a judge. And we all know that the judge is supposed to listen to all the evidence and then, and hear the arguments and then make a decision. So I don't think that this was in any way a sandbagging of the judge.
Well, let me ask you, Ms. Peters, then the prosecutor has a obligation to prove that it wasn't self-defense beyond a reasonable doubt. And how would the prosecutor know, just in any case, that is the defense? I mean, other than intuitively, well, this guy's going to argue self-defense in closing argument. I mean, there is an obligation on the prosecution to prove that self-defense was not warranted beyond a reasonable doubt. So, if the prosecutor is unaware that this is a case of possible self-defense, how is he or she supposed to present that evidence? And I guess my question, I'm getting the question part, is in every case that is tried now, does the prosecutor have to anticipate that it may be self-defense and try to disprove it beyond a reasonable doubt? Does that make sense to you, that in every case, because if you bring it up in closing argument, the prosecutor wouldn't know what the obligation was to prove that self-defense, in fact, there wasn't self-defense beyond a reasonable doubt. And that's what Ms. Steers mentioned, that in an alibi defense, if my recollection serves, I think it's 7 days prior to trial, at least the prosecutor's on notice that, this fellow saying he was at McDonald's when the prosecutor says he was robbing a bank. So that's just my concern, is does the prosecutor now have an obligation in every case to try to prove that it's not self-defense, I guess is the question. Just say run-of-the-mill assault case. And there's no indication, prior to closing argument that it's a self-defense. Do they have to anticipate it in every case? Because I understand the defendant doesn't have to say anything. They can just sit there. They have no obligation whatsoever other than to get into evidence somehow, in this case through the police, that at least in his mind, that tends to prove this, or tends to show that self-defense was warranted. So that's a long question, roundabout way of asking what's the prosecutor to do?
Well, I would just argue, Your Honor, that it's already the state's burden to prove the defendant's guilt beyond a reasonable doubt, that all the elements are met, that the defendant in this case knowingly engaged or knowingly caused or attempted to cause physical harm to a person that qualified in this case as living as a spouse or family household member. And I would just say, by the nature of the testimony as it's coming out, should alert the prosecutor, hey, they're trying to show how she, where they're pointing, but it actually even came out, most of it came out on direct testimony anyway, actually through the prosecutors eliciting that she's the one, she testified, that she yanked it out, that, and contrary to what Ms. Steer said, she readily acknowledged she engaged in a fist fight. On page 22, page 23, we were fighting. And he goes, what were you doing? We were like fist fighting. She acknowledges on page 23 that they were in the hallway, that this fight.
For it to be self-defense, she would need to initiate that, right?
Right, and I would submit that she did.
So where's the testimony that she acknowledged that she initiated it?
Well, she got him to the floor. She said, she got him to the floor, and then she went and she engaged him in a fist fight. There is no evidence prior to this that he was going to engage in any type of physical, I'm sorry.
Well, we were in a fight, or we were in a fist fight is different than I started a fight. I hit him first. Right? Right.
But again, everything that's done is she's initiating this whole scenario. If she had just let him go by and make his comment to whoever he was talking to on the phone, he wasn't even talking to her. So he was not addressing her. She just overheard him say bitch something, and she just assumed he was talking about her.
Ms. Peters, you are at your time.
Okay. just to finish, we would ask that you reverse. Thank you.
Thank you all very much for your arguments today. That will conclude the session of the First District Court of Appeals.